Hi, bankruptcy attorney Brian Barboza, and today I'm going to discuss what is the process for filing for specifically Chapter 7 bankruptcy. Before we get started, if bankruptcy is something you want to talk more about or you want to explore your options, please feel free to give me a call or go to my website, barbozalaw.com. You can book an appointment to speak with me for free directly through the website. Okay, so what is the process for filing a Chapter 7 bankruptcy case? So Chapter 7 is a specific type of bankruptcy. The different types of bankruptcies are referred to as chapters: Chapter 7, Chapter 13, Chapter 11. There's a Chapter 12, there's a Chapter 9. They're all different kinds of bankruptcies for different kinds of debtors. So Chapter 7 is going to be generally for either individuals or married couples or corporations. Okay, and I'm really focused on the individual or married couple that's looking to file Chapter 7 here. And so first, you got to determine, is Chapter 7 right for you? Now, that's kind of a complicated question. It goes way beyond a quick 3, 4, 5 minute video. You got to consider things like your income, the kind of debts that you have, and the kind of assets that you own. Okay, those are all kind of the three-part analysis that needs to go into consideration when determining if Chapter 7 is a proper type of bankruptcy for you to file. But assuming it is the correct bankruptcy for you to file, then the process is going to be pretty formulaic, especially if you're working with a professional like myself. You're going to first of all have to gather quite a bit of financial information. Nothing too crazy, but we're talking a couple years of tax returns. Maybe last 3 to 6 months of bank statements, 7 months of paycheck stubs, maybe a recent 401k or IRA statement, maybe a mortgage statement and a car loan statement, and hopefully a statement from your different creditors like credit card companies and medical bills and things like that. So once you get all those documents organized and put together, then a professional like myself would be going through those and analyzing all those documents, and then we would have to prepare what are called a petition, schedules, statement of financial affairs, a Chapter 7 means test, a statement of intention, and a statement of social security number. So these are all documents that are required to file for a Chapter 7 bankruptcy case. In addition, when you get all those documents prepared, and maybe I'll go through some of those documents in a minute, you also have to do a credit counseling class before you can file the Chapter 7 bankruptcy case. You're going to have to get it's about a 1-hour class. It's online. There's a bunch of companies out there that do it. And then when you finish the course, they'll send you a certificate of completion, and you're going to have to also file that certificate of completion with the rest of those bankruptcy documents I mentioned the day you file the bankruptcy case. And so, for instance, the schedules are like Schedule A all the way through a J. Every A, B, C, D is a different topic. Like Schedule A is your real estate. Schedule B is where you're going to have to list all your personal property. Schedule C is where you exempt your property, meaning protect it from your trustee, from it being taken and sold by the trustee. Schedule D is your secured creditors. E is priority creditors. F is your general unsecured creditors. Schedule I will be your income, and Schedule J will be your expenses. So those are schedules. The Statement of Financial Affairs is another document that's just a laundry list of financial questions, but they all do have some type of legal significance, so you really want to understand why they're asking the question and how to properly answer the questions, okay? And then the means test, Chapter 7 means test, is what determines if there's a presumptive abuse because you make too much money to file Chapter 7, or if it's presumptively proper for you to be filing a Chapter 7 bankruptcy case. So once you get all those documents prepared, they're pretty voluminous, and you get your credit counseling done, then you would be filing the case with the Federal Bankruptcy Court. The case is open that day. There is an automatic stay that will go into effect, and that automatic stay will prevent your creditors from collecting against you while the bankruptcy is pending. Then the court will set a hearing date for you. That's called a 341 hearing, or a meeting of creditors. That hearing is not conducted by the judge. That hearing is conducted by the trustee of your bankruptcy case. The trustee is kind of like the case administrator. The trustee is kind of looking for, number one, is there any kind of indication or red flags of fraudulent conduct, misrepresentations, omissions, concealment? And they're also looking to see what you own, what assets you own, and if they can take those assets and liquidate them to their cash value and pay them out to your creditors. So you're going to have to attend this hearing about 7 or more days before you attend the hearing. You have to provide to the trustee documents that they've requested, tax returns, probably bank statements, the last 90 days of paycheck stubs, and any other document the trustee has requested in advance. So you got to get the trustee all those documents. If you have an attorney, they'll do that for you. And then you'll attend the hearing. And if you have an attorney, the attorney will attend the hearing with you. And after the hearing, you'll have about a 60-day window where you don't want anything to happen, because that additional 60 days gives your creditors and the trustee a chance to look over the case, determine if there's any basis or grounds to object to your bankruptcy case. Assuming that there are no objections, then the judge, after that 60-day period, should issue an order declaring that your debts are discharged, at least the debts you can legally discharge in a Chapter 7 bankruptcy case. And there's one more little thing that you do have to do. There's a deadline after you file the case. I always tell my clients to do it before the hearing, but there is a deadline for you to do a second class. This is called financial management. Sometimes it's called a debtor education course. And that class is online, just like the credit counseling. You have to get a certificate of completion, and you have to file that with the court as well. If you don't file it on time, then the case would be dismissed and you would not get a discharge. So that would kind of be the last thing you need to do, is get that financial management course certificate filed with the court timely. And then, as I mentioned, as long as there's no objections to your discharge or the dischargeability of a debt, your case should close within that 90-day period. Now, if you do have assets that the Chapter 7 trustee does take from you and liquidate to give your creditors some money, you will get your discharge within those 90 days, but the case could stay open administratively to afford the trustee time to liquidate the asset, issue a report, send out checks, and close out the case. So if it's an asset case, then your case would be open longer, but the discharge period doesn't change. Okay, so that's it in a nutshell. That's the process of a Chapter 7 bankruptcy. It can become very complex and complicated, so I do advise you talk to a professional. If bankruptcy is something that you want to explore, feel free to give me a call. Go to my website, barbozalaw.com. Book an appointment to speak with me for free through the website. As always, thank you for watching this video. I appreciate your time, and have a good rest of your day. Take care. Bye.